Well, good afternoon, everyone, and welcome to this very important forum co-sponsored by the Cleveland Marshall Alumni Association in partnership with the Cleveland Metropolitan Bar Association. And I do want to give a special thanks to John Calabrese, who's the president of CMBA, and also Rebecca at the Metro Bar. I think that this is a very uncertain time, and that in times of uncertainty, many look to the legal profession for some guidance and some clarity. I'd like very briefly to introduce our panel here today. On behalf of the Legal Aid Society of Cleveland, we have Hazel Remesch.
Hi, everyone.
And on behalf of the firm Powers Friedman, we have Lisa Friedman.
Hi, everyone.
So for both panelists, I do want to start with, I guess, a somewhat startling statistic, as was recently reported on NPR and other outlets, that 1/3 of American renters were unable to meet their rental obligations during the first week of April. And so with that in mind, I did just want to move into some of the common issues here that many of us as advocates and in the general public are hearing, and to just really allow the panel to, to speak. Again, for all those who are watching or listening, the purpose here of this panel is not necessarily to give specific legal advice, but rather to have a general discussion of these issues and to provide some reassurance to folks out there that there are hands on the wheel. So to the panel, a great number of renters are stuck with regards to applying for unemployment. It's no secret that the state's unemployment organizations are overloaded at this particular point. But in many cases, those renters have still received some form of notice for non-payment of rent. I'd like to open this up to the panel just for a discussion on how that relates to a tenant who in good faith is making every effort to apply for unemployment or other assistance, what kind of impact that's having. We'll start with Hazel.
So at Legal Aid, we represent tenants who are anyone that's eligible for legal representation at 200% of the federal poverty guidelines. And we're already seeing a lot of calls coming in, a lot of tenants calling, and just general people in the general population that are saying, I've lost my income. We're getting a lot of questions about unemployment compensation and what to do with when with a landlord who's given you a notice. And so those calls are already coming in, and we anticipate that people who generally would not be eligible for legal aid representation may become eligible now because of this crisis. And so we've been encouraging folks to work with their landlords. We think this is a time where we're apart, but the community is coming together. And so really to try to work with their landlords and with just with the community as they're, facing these issues.
I want to switch now also to Lisa. Is this something that your firm is hearing? What are some of the things that that this whole rock and a hard place of non-payment of rent, but also trying to get through to, and unemployment system that really appears to be overloaded at this time?
Thank you. I would say that one of the most important things that a tenant can do, we do represent landlords. And one of the most important things that a tenant can do is communicate with the landlord. The problem that we're seeing right now is so many of our clients have people that were non-payment pre-COVID-19. So we have clients that had non-payment of rent issues with their tenants from January, February, and March. And now they're definitely still not paying April. So they are unable to get a court hearing date for those, for the pre-COVID evictions. And with regard to April, I'm definitely hearing from pretty much across the board that our clients just want there to be communication with the tenants. If a tenant comes, I had a call yesterday where a tenant came in and said that they could not, they were waiting for their unemployment, and the landlord understood that, but at least that tenant communicated. The landlord was completely, open and happy to let that, tenant make a payment arrangement. But that's the most important thing, I think. But there is just such a huge lack of communication right now between the landlords and the tenants. So the landlords really do appreciate when tenants come forward and try to come up with a plan to move forward.
Yes, and I think also, again, speaking also on behalf of Cleveland Marshall, I know that many organizations have a copy of a tenant hardship affidavit that was produced by our community advocacy clinic there. When we're talking about communication, I know that is oftentimes a point of some confusion, just in terms of whether or not that communication is best, coming via a phone call, a text message. Could the panel maybe discuss a little bit, obviously appreciating Lisa's point here about keeping the lines of communication open. What should folks be doing here in terms of communication? I'd like to turn it back to Hazel.
We always encourage tenants to communicate in writing if possible, an email, a text message, just some sort of record that they can, keep for their own record keeping. I will say though, in terms of communication, so there's a couple of different renters that are going to be in different circumstances. So you have renters that live in subsidized housing, for example. Anything that's subsidized by the federal government is going to be covered by the federal eviction moratorium. And so for those tenants in particular, they need to be reaching out to the housing authorities, to their, their mission-driven landlords. They need to be reaching out to them. They need to be telling them they've lost their income so that their rents can be adjusted. So that's one pool. And then there's the other where it's a private landlord-tenant, relationship. And for those, we always encourage that they communicate in writing if possible, and preferably via email or text message.
Lisa, do you have some? I'm happy that Hazel brought up the federal moratorium. I know that I don't know exactly your client base, but I do know that your firm is very well respected amongst landlords. What percentage of your clients could you maybe ballpark as are potentially impacted by the moratorium that was issued by Congress, I believe, just this past week, March 27th, I believe it was?
Well, first of all, I would say if I had to make an estimate, it would be 50%, because the problem you're talking about, when people have received HUD money or Section 8 money, but there's also the issue of whether the landlord receives their mortgage or has financing through Freddie Mae or Fannie Mae. Fannie Mae, yes, sorry. And so you're opening up, everybody is going to have, there's so many clients that are facing these issues. There's very few that don't have to rely on the CARES Act at all. I mean, but that doesn't apply the CARES Act. That's for non-payment of rent. And the evictions, you know, the courts have been, and the other issue is that there are so many courts around, that so many municipal courts that are all handling things differently. And right now we're getting different advice from everyone. Some are saying that they'll do evictions, you know, based on emergency circumstances. Is there criminal conduct? Is there a health and safety violation? Things like that. And so you know, the non-payment of rent is one part of our practice, but there are also the evictions that are for cause or for other reasons. And it's very confusing, and it's confusing to us. It's confusing to the courts. It's very difficult to navigate that. And it absolutely is a case by case basis. But to your question, I would say at least 50% right now of our clients are subject in some way to the CARES Act and federally funded, you know, mortgages or receiving money from HUD for tenants.
I note that we, and this is also going to be just a general PSA for all of those attending. There will be a Q&A portion of the program as we move into 3:30. So we have been documenting the questions that have been submitted here. There are a few questions, you know, going into more detail with the CARES Act, and I think that may be a large portion of the second half of this webinar. So all those who did submit questions relative to the CARE Act, please hold on tight. We will get there, but we did want to discuss a couple of the other nuts and bolts issues that are here present locally before we move on to discussing the national response. Related, I think, to issues of non-payment with regard to the unemployment, the rock and a hard place. You know, obviously this is a time where many folks are very concerned about their health. I have to say, when I went to the grocery store earlier today, I certainly wore a mask and was wearing gloves. One issue that has popped up for many folks is that a landlord may issue a 24-hour notice, as they are allowed to do under law, to enter the premises for purposes of inspection, repair, etc. And the tenants may have some concern as to whether or not the landlord or their agents will be properly protected, what kind of protection is being taken there, so that a reasonable request to enter the property will not inadvertently contribute to this potential spread of the virus. Lisa, do you have any thoughts on that? You know, speaking as counsel for landlords.
Yeah, that's a dangerous question. You usually don't want to ask me for my thoughts, because I do have a lot of thoughts on that. First of all, we are seeing predominantly, I'm going to say every call that I've had is more so that tenants want work done in their unit, not that our clients are posting 24-hour notices. We haven't had one, I have not, and I don't think that anyone in our office has had a phone call from a client that is saying that landlords we're trying to get in to do repairs in a unit, and they won't let us in. That's really not happening as much as you may think. It's more so the other way. Our landlords want to protect themselves and their employees. So we have had several landlords who have, you know, tenants have called for maintenance, and the landlord will say, okay, we'd like you to pick a time, leave the unit, and we'll get our employees in to do the repair work. The other thing to keep in mind is that repair work has to be done on an emergency basis. You're talking about 1/3. You started this seminar with 1/3 of tenants have not been able to pay their rent. Well, how do you think that is going to impact what the landlord can and can't do? I mean, it seems like landlords are getting singled out right now. I mean, we're all struggling with, in one way or another, with what's going on with COVID-19, but landlords don't have unlimited pockets, and they've got to use their resources. So if there's an emergency situation, that's going to take effect, you know, that is going to be prioritized. But even when it's an emergency situation, the landlord doesn't want to subject their tenants or their employees to possible contagion. So our clients have really been, I think, making a very, very good effort to try to get into the units when the tenant vacates, you know, wearing masks, wearing gloves, sanitizing where possible. But I'm not seeing it as much the way you pose the question, that tenants want work done. I mean, we've had a few minor requests that the landlord's saying, listen, we can't get to that right now. We're going to take them emergency only. So that's what we're seeing from the landlord side.
Sure, Hazel. Any thoughts on that? You know, obviously, you know, there are instances where, you know, a landlord may have a property manager or something else there, but speaking to the prompt, what kind of situation does that put a tenant in if they are in a situation where, you know, a landlord may reasonably want to access the property, but are not, there may be some questions about what the landlord or their contractor, their agent may be doing with regards to precautions, just from your perspective there.
Yeah, I mean, I think what the revised code actually says with regards to a tenant's obligation in that scenario is that the tenant can't unreasonably withhold consent for the landlord to enter the unit. And so, you know, I would argue that in this particular instance, a tenant saying, look, I have I have a compromised immune system, or, you know, for some reason, I really, you know, I've been social distancing or isolating, and I really don't want anyone coming into my house. I don't think that would be an unreasonable withholding of consent. And so, you know, I think tenants have to be, to Lisa's point, you know, what I've been advising our clients and the people that I've been talking to is, you know, you have to be flexible, you have to communicate, you have to, you know, reach out to your landlord and express those concerns. And if you have concerns, then, you know, hopefully the landlord will listen. And, but I don't think it's unreasonable for a tenant to withhold consent to enter a unit, given our current circumstances that we're in, you know, and sort of the stay-at-home order and all of the social distancing that's going on.
Sure. And again, I just want to keep us on track here as we approach 3:20, understanding that we do have some questions coming in. Lisa, I do think that you raised a very, very good point as we were talking about repairs and, you know, the needs of landlords. I do work for a community development corporation, and we do have many landlords in our area which are essentially subsistence landlords. And by that, I mean they are using rental payments more or less to offset the cost, or I'm sorry, offset their living expenses that they may be getting from Social Security, for example. If you're an elderly landlord, maybe in your 60s or older, I have seen a fact pattern numerous times where there is a landlord who themselves are low to moderate income. Lisa, this particular situation that we find ourselves in with regards to landlords that may not necessarily be able to keep up on their obligations to repair as a result of non-payment. If there are any folks in that situation or who may be thinking that this could really cause some long-term issues in terms of repair or maintenance, what are some things, or I guess a better question would be, what are some resources that you may be directing your clients towards if they fall into a situation where their cash flow is now gone, and so they may not necessarily have the resources to maintain the property?
Okay, so well, first off, the banks are offering a forbearance for mortgages, but the problem with that, as it's written right now, is that you can not pay your mortgage for 3 months, but then you have 12 months to repay it back. I don't have a crystal ball, none of us do, but I don't see that if you can't pay your mortgage for 3 months and you hold your cash, we're not going to be out of this in 3 months. And so to go into an agreement knowing that you're not going to be able to fulfill the terms is difficult, but it's dangerous, but it may very well be the only thing that the landlord, the smaller, even the bigger landlords, this isn't just like a mom and pop landlord thing. This is clients that have hundreds of units that are going to have a hard time paying their mortgage. And then to say that they have only 12 months to repay the 3 months plus the ongoing, I mean, I don't know that their tenants are going to be in a position 3 months from now to be current. So, and right now, if they can't file an eviction until August, then how are they going to get the unit turned? With what money are they going to turn the unit? And where are they going to get the money to act? I mean, it's just, it is definitely, I don't think it's not a perfect situation. It's going to be very difficult to not pay your mortgage for 3 months and then make it up in the following 12 months. That being said, if the landlord chooses to not pay their mortgage for 3 months and takes advantage of the forbearance agreement, they'll have presumably a little more cash flow. But if, it's a landlord that only has one tenant and this tenant isn't paying rent, their obligation is to do emergency work and things that will make it safe and habitable. Obviously, things that are not an emergency situation are not going to be able to be done. And you are right. Everybody just needs to be a little more reasonable with each other and understand that we are all in this together, and everybody's just going to need to do a little give and take. But I will tell you that at my house, a toilet broke. I can't get a maintenance person to come in. I'm the landlord in my own house. So I have to deal with it. I mean, everybody has to be a little more reasonable and try to work through this the best way that we can.
Hazel, and I think what I'm hearing also from Lisa's comments with regards to the issue with the mortgage payment, the issues of extending payments on, tacking those on to the end of a 12-month. One of the things that we've been very sadly discussing at my organization and also others is the impact that this could potentially have on displacement overall, and whether or not we are seeing similar circumstances, although caused maybe by a different factor, but very similar circumstances to those that led up to the housing crisis of 2008. Understanding that a lot of folks on both the landlord and tenant side are almost caught between a rock and a hard place here. Hazel, what would you what are your thoughts on or I guess what comments might you have for people who may be in a situation where either as a tenant now maybe looking at some kind of displacement, or as a landlord now in a potential situation of being foreclosed upon, what kind of resources are you seeing that might be of good use to folks who find themselves in that situation?
Well, I will say, first of all, that I don't necessarily think that this is going to be like 2008. I think it's going to be way worse. I think what we're experiencing here, we're going to have massive displacement if the resources don't kick in. I think this will be the first time that Lisa and I will agree that landlords should have money in their pockets. I'm all for that right now. And I think that because it's necessary in order to maintain the housing stability and to maintain the market. And so if resources don't kick in, we're going to be experiencing massive displacements in numbers way exceeding what happened in 2008. And I think it's going to have an impact across the board. It's going to impact landlords, it's going to impact tenants, it's going to impact our justice system and the ability for the justice system to carry out justice and access to the courts. All of it is going to be impacted if if the right resources aren't coming in. So I don't think this is something that, while similar to the housing crisis in 2008, I think, and we can learn from some of the resources that happened back then, I think this is really unprecedented in terms of what we can expect. With regards to sort of resources that are available, I really encouraged, if people have questions, Legal Aid has a tenant information line. Our website is filled with resources right now of what's available in response to the COVID-19 pandemic. So I would encourage folks to reach out to to go on our website, call our intake, call our tenant information line, and we'll try to get some resources out to you.
And I am both, I think, probably during the panel and then also afterwards, I will encourage everyone to look at the CMBA social media. Obviously, there are a host of resources that have been brought online or are coming online. And I know that sometimes that can almost be intimidating to wade through all the various resources to see whether or not a person qualifies for this program or that program. But I do want to encourage all those who are participating in this webinar that there are resources available. And that we really do have some very fantastic organizations that are able to get that information out there. I wanted to shift very briefly and talk a little bit about, or I guess pose to the panel, some of the impacts that this is having on the access to the courts. Unfortunately, there is a lot of things happening over at Housing Court, and we were unable to get a representative from the court with us today, but they do send their apologies for that. They are the largest single judge docket, I believe, in the state of Ohio. And so they certainly have their hands full. But one of the common issues that was already on our plate to discuss was issues regarding the courts. And again, primarily with regards to either a tenant's ability to place their rent in escrow, or conversely, in certain circumstances, using the court to file for other things, like a temporary stay or a temporary restraining order. I am sorry that we don't have a representative from the court here, but given the fact that both panelists have extensive contact with the court and the judiciary, I'm wondering if we can maybe walk through a little bit of that as we transition to the Q&A portion of our presentation. But just some general thoughts, and we'll start with Lisa on how this is impacting, how the court's closure is impacting the abilities of parties to access the judicial system.
Thank you. Well, right now we know that Cleveland Muni Court, I think, is closed until April 20th, but we have been told that if a landlord has or requires an emergency hearing, that we can make arrangements to hopefully get that heard. I mean, like I think I brought up earlier, an eviction for criminal conduct or health and safety. I had a client call that said that a tenant who tested positive for COVID-19 was running around coughing on other people's doorknobs. So what do you do? We absolutely have to have access to the courts, and everything from the Supreme Court of Ohio, it seems like they wanted the courts to remain open in some capacity and for emergency situations or emergency evictions. And fortunately, we haven't had to file anything yet for an emergency, but I don't think that it would have been nice to have a more uniform policy from the entire court community, but we don't. We have a list that was changing about 2 weeks ago. It was changing by the hour, every municipal court and how they were handling, whether they were accepting filings, not accepting filings, having hearings by phone, not having hearings. So it is definitely very scattered, and I think it's a little disorganized. But that being said, we have been assured that if we did have an emergency situation or a client that required an emergency hearing, that they would be able to get that. And we still could file an eviction for criminal conduct if we needed it, to protect the health and safety of the tenants in the building, the other tenants.
Sure. Hazel, any thoughts there? I know that there is one question, just to kind of use this as a great segue into our Q&A portion, but speaking from tenants' perspective as an advocate there, with the court being closed, if a tenant seeks to access the escrow remedy under Ohio Revised Code, how are these closings impacting that?
Well, so, I think this is a big question, and it's so much of it depends, again, to Lisa's point, as to what court you're in. With regards to specifically speaking about Cleveland, you could, depending on what the condition is, if it rises to the level of an emergency. So for example, a person doesn't have water, or they don't have heat, or whatever emergency level it is, we could always access, or a tenant can always access the court via an emergency motion for a temporary restraining order. I think the rent deposit process, whether that's going to be a process that's available to the tenants right now, it's a big question. And whether the court is actually accepting the rent into escrow. I don't know the answer to that, to be honest with you. I will say that what we've been advocating and sort of telling the tenants is, if you have a condition that is happening in your unit and it's not an emergency situation, just hang tight. Keep track of what the condition is. Don't withhold your rent. If you're able to pay it, pay the rent. If you're able to, and just keep track that you gave notice to the landlord. And when the dust settles, we can come back and revisit that. If it's an emergency situation, it should be covered, and they should be able to have access to the court via a temporary restraining order or some other sort of emergency motion.
Well, I think that really does highlight that, and I think what I'm hearing from both of you is that the legal community is really hoping for some additional guidance to come from the judiciary, from the Supreme Court of Ohio all the way on down. These are very uncertain times, and I want to reiterate again for all of those who are following us here that if you do have questions about your specific situation, that there are resources available out there. And we will be sure that at the conclusion of this, that some numbers and some email online intake information is distributed. I want to move into our Q&A, and I thank the both of you for your time. This is without a doubt kind of the cutting edge of landlord-tenant law right now. I want to return a little bit to some of the discussion we had at the top of the hour regarding the CARES Act. We have a question coming in that I don't particularly, Lisa, I don't know among your clients if any of them fit in this parameter, but we do have a question here regarding the moratorium on evictions. Is that everything that is basically touched by the federal government, or is this more narrowly tailored? Because there are some comments here that we have been seeing that the provision in the CARES Act about properties with a federally backed mortgage loan basically is like almost, I mean, it seems like that might be a very high number of properties. So I'd like to turn that over to the panel to have some discussion on that.
Thanks. My understanding is that the CARES Act, it does apply to a lot of our clients. A lot of our clients are backed by Fannie and Freddie, and a lot of our clients do take HUD subsidized tenants and Section 8 tenants. However, my understanding is that it is a moratorium on non-payment of rent cases for those clients that are subject to the CARES Act. In situations where there's an eviction other than non-payment of rent, they are still able to file it. Now, whether the courts are going to give us a date, accept the filing, set a hearing, do anything with it, or have a move out, that's a whole nother story, because the tolling order from the Supreme Court, it seems very challenging to read it right now, because they seem to have made an exception in the tolling order from the Supreme Court for evictions, but they toll time limits on everything statutorily based. So a 3-day is a statutory notice. So we have to deal with the CARES Act as well as the tolling order from the Supreme Court. And it would be great to get a little more clarification and guidance as to that. But as I understand it, if you have an eviction for other than non-payment of rent and you are subject to the CARES Act, you can still file it. And if it was for health and safety of other tenants, we would still advocate on behalf of our clients and try to get a date. But we're very careful to say, we just don't know how the courts are going to handle it. We don't know whether the bailiffs, if we actually get a hearing and get them and it's granted, are the bailiffs going to go out and do the set out? We just don't know. So there's also the stay in place that we have to, the governor's stay, which, you know, we're dealing with. So there's definitely a lot of confusion for everyone.
Sure.
Now, that's not really a great answer, but that's what we've been dealing with the past few weeks.
Sometimes the honest answer may not always be the best answer, but you know, that is our reality. Staying on the theme of the CARES Act, Hazel, I want to shift over to you because we also have a question about whether or not housing choice voucher or is this more impacting project-based units, like, for example, those that are constructed under LIHTC, which, for those who don't know what LIHTC is, that means low-income housing tax credit. Do you have any thoughts or some insight or some comments on that particular piece? Do you see people with vouchers, contacting legal aid and other organizations like that during this time period?
So my understanding is that it pretty much covers federal housing rental programs, including the Section 8 voucher program. So public housing, Section 8 project-based, and a variety of other programs that are covered under that would fall under the CARES Act. There is a nuance about it though. What the moratorium does, it prevents a landlord who is covered under that act from filing the eviction and from charging late fees and other associated fees. So it's really related to non-payment of rent cases. That's what it's covering. And then the other thing is that it requires that a landlord give a 30-day notice after the 120 days have lapsed for the moratorium, which became effective March 27th. So just a couple of nuanced details there. But my understanding is it does cover project-based Section 8 and the voucher program and some of those traditional programs that people are familiar with.
I am, and thank you both. We are happily getting some really great questions here, and so I apologize if I am kind of on and off here because in addition to to hearing you and wanting to keep the conversation moving, I'm also looking at these really incredible questions here. Now, I do want to shift also. We have a lot of really great institutions of higher learning in the greater Cleveland area, Cleveland State, Case Western, obviously the two big ones, but other schools as well. And one of the questions here is that related to the eviction moratorium is that the rental obligations for students who may in fact be covered by student loans issued by the federal government. Basically these students now, because their university campuses have closed, I remember back to my college days, I certainly used a portion of my loans to help, with the basic cost of living. But whether or not those students may be impacted or covered by the federal CARES Act. Does anyone? I don't know.
Okay, I'll go. I personally do not believe that if you have a federally backed, unless I have not read that, so I could be wrong, but if you get your loans through the government, I do not believe that subjects you. You could still be, if your landlord is not subject to the CARES Act. Otherwise, I think they could still probably evict based upon that. However, I will tell you that there is no one has said yet that these debts are going to be forgiven. So you have to tread carefully. I have two students at Ohio State. I'm paying rent. I've got to pay rent. Oh wait. So I have two students there and I have to pay their rent. And that is the way it goes. I think that I don't believe that unless Hazel knows the answer to that. I'd still, try to pay your rent. I would communicate with your landlord. I would try to, do that. The debt is not going away. As we sit here today, we are also getting a lot of calls from people that have not lost their jobs, are not suffering a financial hardship, and they just think that because there's an eviction moratorium, they don't have to pay their rent. And I think that's a bad idea. Don't just not pay your rent for no reason. And just communicate. Back to what we started at the beginning, communicate with your landlord. My son's got friends who have done that because they cannot pay their rent. And so far, the landlords have been pretty good with honesty and an open line of communication.
Hazel, do you have any thoughts or comments there?
I really don't know. I mean, I know that there's like a statewide group at Ohio State that's looking at that particular issue. And it's part of the sort of the housing program at Ohio State, but I don't really have any additional information on it.
Okay. Now, I guess, I'm sorry, what?
I was going to respond. There is one question in the comments that I wanted to respond to, and it's regarding the tolling order and the eviction moratorium, and this idea that it tolls back to March 9th and not the 27th. For clarity, what I was talking about, the March 27th, that's when the CARES Act was signed. So that's different than the tolling order from the Supreme Court of Ohio, which does go back to March 9th. So just clarifying that point.
No, thank you. And I had also seen that in there. Kind of keeping on the multifamily, track. I mean, I remember, again, back to my college days, there was a large multifamily, complex. There were some shared entrances, exits. There was a question coming in regarding whether one tenant in a multifamily, what I believe is a multifamily building, what are potential rights or obligations one tenant to another if a tenant invites guests over that may I don't know that may not be practicing social distancing, or that if one tenant has concerns that another tenant is potentially doing things that will exacerbate the medical situation. How should tenants and the landlord for both of those tenants, what are some things that should be considered in trying to resolve those kinds of issues? Lisa.
Okay. Well, are you specifically asking, you're asking tenant to tenant, like in the unit? I mean, if it's a neighbor, you could ask them to please, you could ask them to stop. And we've been telling our clients, they can't just go and do things. If they think that they require help, call the police. The police can separate it. I would definitely shy away from taking action myself or having the landlord try to do that. I mean, you might want to put a note on their door as a gentle reminder, but if it got out of hand, I mean, honestly, you got to call the police. Let them handle this. This is an order by the government, and it's something that everybody needs to take seriously. But I thought when you said between tenants, I just wanted to bring that up. I was thinking joint and several liability. That's another line of communication. I, for example, wanted to make sure that if my son's other roommates did not pay rent, that his landlord did not come after him. I gave him assurances that I would continue to pay the rent. And he was very fair and wonderful to work with. And he said that he thinks everything's going to be okay, but thank you for communicating, and he won't involve my son in any, litigation after the fact to try to collect the money, because I'm going to continue to pay, and otherwise the lease he signed is joint and several. I could still pay my rent, and then the landlord could come after me for the unpaid portion, or my son. So I communication is obviously important, but I would definitely tell a landlord or other tenants to call the police if they think that they need to.
Hazel, would you like to kind of weigh in on that particular situation?
Yeah, I mean, I think that, you know, under the regular course, I would say housing court specialists tend to be a really good resource for for tenants and landlords. And, you know, under a regular circumstance, I would say the tenant can notify the landlord that that's what's happening on their property. And maybe the landlord would be willing to intervene in some way without necessarily having to go to the property. You know, I guess I just want to shy away from calling the police department unnecessarily, given everything that's happening in our world. But definitely, if it gets to a point of escalation, and that's what's needed, you know, I think it's hard right now to tell tenants under normal circumstances this is what you would do, because nothing is really normal. And so, you know, going back to the initial theme of this conversation, which is try to communicate with that tenant, try to communicate. And I think the question that you were referring to was like a side-by-side unit or like a duplex, I think is what the question was alluding to, or a multifamily unit where there's multiple units in a building, and sort of, you know, how do you address the conflict between those two tenants when one is not, you know, practicing social distancing. And I would, you know, sort of go back to that, communicate with them, you know, hopefully, you know, hopefully they'll be willing to work with you, but also that tenants can do things to protect themselves. And, you know, and I'm not talking about legal, I'm talking about things like you hopefully wipe down the areas in your, you know, around the common areas. I don't know, maybe reaching out to the landlord and explaining to the landlord what's happening, and maybe the landlord would be willing to do some of that. I think we have to get creative. We have to get creative about how we address some of these issues in ways that we normally wouldn't.
I think I can certainly echo that. Wow, what a fast hour it has been. We are right now at 3:52. I think we can do maybe one more question here, and that is more or less relative to, we did have a question coming in, and just briefly, I know that this is a forum for residential issues, but if the panel could maybe clarify or distinguish residential versus commercial, whereas in the commercial space there is a governor's order that I think is being treated as pretty persuasive circumstantial evidence, and just maybe distinguish between the commercial issues and maybe the residential issues. Hazel, if you could maybe take a first stab at it.
Yeah, I mean, my understanding, and I don't practice, you know, I don't do any commercial stuff, but my understanding is that there is an executive order from the governor that addresses commercial evictions, but that it's really a request, not an order. And so I think there's been some dispute in the legal community about how that's going to be interpreted, but generally, I think the majority, the expectation is that it's going to be followed, and that there shouldn't be commercial evictions during the period of time that the order is in effect.
Sure. Lisa, just to kind of flip that question back to you, we only have a couple of minutes left, but we did have a few questions, you know, to basically distinguish the commercial tenant situation from the residential tenant. I know that the subject of this webinar is residential, but you know, given the fact that we have only a few minutes left here, I just wanted to maybe have some thoughts on the distinguishing, or I guess you could say the two tracks between commercial and residential leaseholds in this time.
Sure. Well, landlord-tenant relationship with commercial leases is not governed by 5321. There's not a landlord-tenant. They are lessor lessee. Okay, so they're not subject to the same rules and regulations and statutes. So we believe that we can have a commercial eviction, whether the governor tolls that, whether, you know, no idea. Whether the governor says we're not going to have that, that's a higher than my pay grade. But we believe that we can still have a commercial eviction. Now, do you think that a commercial landlord wants to evict somebody right now? I mean, they know they're not paying rent. Who are they going to get in to replace them? So, you know, the best thing is going to be to work it out with the commercial tenant. So, I mean, that's really where we're at. It's not subject to 5321. It's very different. The notices are different. The notice requirements, it's very different, commercial evictions. And we think that they can go forward if the courts will accept filing and give us a date, which remains to be seen. But it's very different, and it is not a landlord tenant, it's lessor lessee. So that's the biggest distinction.
And I think, unfortunately, there is a lot which remains to be seen as we head into the month of April more fully. I know that the latest updates from Dr. Acton, the governor's briefings seem to suggest that Ohio's spike in cases may happen this month, may happen later this month. I did just want to, with the 3 minutes that we have left, if folks who are listening may have joined late or they'd like to share the contents of this discussion, this will be a part of the CMBA's Facebook page, and will also be distributed digitally, so that if you would like to, you know, refresh yourself or to at least maybe share with your friends or neighbors who may have a situation, you know, that I found, you know, both as a practicing lawyer and as an adjunct professor of law, I found this conversation to be very informative, and just also want to again remind everyone that there are resources and organizations providing those resources, helping to guide folks through this situation. We will be sure after this panel to have various links to those resources, and we would just encourage everyone to remain calm, take a deep breath, and we will get through this period together. I want to thank both of our panelists here today, Lisa Friedman from Powers Friedman, Hazel Remesch from the Cleveland Legal Aid Society. Thank you both. I have a tremendous amount of respect for both your organizations, for the time and commitment that you have. And again, a final thank you to the Cleveland Marshall Alumni Association and Cleveland Metropolitan Bar Association. We have a very strong legal community in this area, and it's a real, I think, help when we can have those who typically represent the tenant side, those who typically represent the landlord side, come together and really use their expertise to help in this time of uncertainty. So thank you very much, everyone, for your attendance, and please stay healthy. Please, you know, take every precaution as we move forward. Thank you very much, and have a great afternoon.
Bye, everyone.
Thank you.